Today I'm going to give a quick overview of the neglect system in Washington, D.C. In other words, what happens once a child is removed from the home of a biological parent and brought into the foster care system in Washington, D.C. Now, once children are brought into the foster care system, the court has jurisdiction to make decisions about the child's life. And the most important kind of long-term goal that the court has to look at is what is the permanency option for this child to get out of the foster care system. And there are several different permanency goals. The first one is reunification of the child with a biological parent or parents that the child got removed from. Now, reunification is normally the first goal in these cases in the neglect system in D.C. because the court wants to find out what led to the child's removal and what can we do to get the child back home with biological family members. Now, that might look different in different cases. If it's an abuse case, the parent might need to be taking parenting classes, anger management classes in order to get to a point where the court feels comfortable having the child return home to that biological family member. If it's a drug abuse case and the child was exposed to drug use in the home, then the judge might need to order services for the biological parent to get treatment for substance abuse. Now, the reunification goal for children in the neglect system is set up so that usually there's a set amount of time for the parent to work with a social worker to get services to essentially ameliorate the circumstances that led to that neglect or abuse. Now, the reunification could be with that biological parent that was alleged to have neglected or abused the child, or it could be with another biological parent that maybe wasn't involved at all. That would also be considered a reunification of the child with a biological family. A second option, a second permanency goal for children who are in the abuse and neglect system is adoption. Now, when a child is adopted by anybody, the court considers that the adoptee was actually born to the adoptive parents. There's a termination of the parental rights of those biological parents that the child has. But the adoptive parent could reach an agreement with biological parents for post-adoption contact. And an adoption, if there is an adoption of a child out of the neglect system in Washington, D.C., that cannot be modified unless there is some kind of defect in the motion for adoption within 1 year. Now, a third possible option for children coming out of the neglect system is guardianship. Now, guardianship is a process where someone other than the biological parent moves the court to get guardianship over the child in order to make major decisions concerning the child's life. Now, those types of major decisions are things like consent for marriage of the child, to go into the armed forces, to make major medical decisions, surgical, psychiatric treatment, those kinds of major decisions. Now, in a guardianship situation, and by the way, guardianship is available to both kin of the child and non-kin. For instance, like a long-term foster parent where the child's been living. If there is a guardianship, then the birth parent's parental rights remain intact. They're not terminated. And the birth parent's parental rights include things like reasonable visitation on an ongoing basis. So the guardian is making decisions about when and where visitation is occurring between the child and the biological parent. Now, if there's a guardianship, what happens is that the neglect case that had been open essentially goes dormant. The case effectively closes without any further hearings scheduled, but it can pop back open if there is a motion to modify that guardianship that had been established. So for instance, let's say we have a guardianship on June 1st of 2013. The judge issues a guardianship order for the aunt to be the guardian of the child, but then on June 1st of 2013, 6 months later, there's a problem. Maybe the guardian becomes ill and the fallback guardian is not available. The biological parent might make a motion to the court to modify the guardianship, or maybe another person might come in who wants to become the guardian. Now, The only way that a guardianship can be modified is if you can allege that and prove that there's been a substantial and material change in the child's life. And that it's in the best interest of the child for the guardianship to be modified. So if that does happen on June 1st, there's a motion to modify the guardianship, then the neglect case that had been kind of sitting there dormant without any hearings scheduled normally pops back open. Now, we don't have statutory provisions that state that clearly, but judges typically do that. They'll pop back open the neglect matter. The guardian ad litem from the Children's Law Center or from the GAL panel will get involved in the case again. All the lawyers will be called and there'll be a hearing on the guardianship and the neglect case. And normally it'll go back to the same judge who had the case earlier. So between the two permanency goals of guardianship and adoption, there's usually a lot of thought that needs to go into the decision that a caretaker is going to make about whether or not to seek guardianship or adoption. There are a lot of pros and cons to each. Now, like I said earlier, when you have an adoption, the biological parent's rights are completely severed. They're terminated. The biological parent no longer has any legal relationship to the child. They cannot seek visitation. They cannot be involved in decision-making if the adoptive parent chooses them not to be involved. If that biological parent whose rights are terminated tries to go to court and exercise some authority over the child, they're not going to win. Their rights are terminated. So what if a caretaker decides to seek adoption, it's really the most permanent of goals because you have terminated the biological parent's rights and you are the decision maker from there on, as if that you gave birth, you or your spouse gave birth to that child. So it's a very it's a very effective way for a caretaker to kind of assert complete control over the child's life. Now, guardianship, on the other hand, is not as permanent, even though the order sometimes says it's a permanent guardianship. As I mentioned earlier, that guardianship can be modified. And caretakers who choose the guardianship route usually have to go through this analysis of like, okay, what is it going to look like for me to take care of this child on a day-to-day basis, be making day-to-day decisions about the child, but have the biological parent or parents maintain some kind of relationship with the child, maintain some kind of visitation regimen with the child. Now, that caretaker has to weigh a couple of competing interests. On one hand, that caretaker might think, you know what, it's good for this child to have some kind of ongoing relationship with a biological parent, and I think it's important for the child to know and have a relationship with that biological parent, to know where they come from. That might be a decision that the guardian thinks is valuable to the child. Now, there might be other situations where the guardian or where the caretaker is looking at this decision, looking at the effect that the biological parents have on this child, and say to themselves, you know what, it's a negative relationship. There's too much heartache, harm being done to the child. It's not in the child's interest to have visits. They go badly. The biological parents are somehow cruel or nasty to the child, or they bring some major drama to the child's life every time they have an interaction. So that caretaker may choose an adoption route if they are seeking a clean split for the benefit of the child. And sometimes that is in the best interest of the child. And it's one of those situations where it can be a very, very challenging decision to make, and it's one that you have to think through and get advice from counsel about. As attorneys for caretakers, you have to be very careful to understand exactly what the client wants, why they want it, and what you can do to get them to where they want to be. As a representative for the caretaker, you represent their stated interests. So if they are telling you that they want a clean split, that they want to be the ones making the decisions, that they don't want to be involved in the drama of the biological parents' interactions with a child, that's your job, is to counsel them about the differences, and If they choose, after hearing the pros and cons, that adoption really is the appropriate route, then that's what you're going for and that's what you're fighting for. Another permanency goal for children who are in the neglect system is custody. Now, a legal custodian for a child makes long-range decisions about their life relating to education, discipline, and ordinary medical care. Now, sometimes a legal custody action between two biological parents who are involved in an open neglect case will help the judge be able to close the neglect case. For instance, if there's a situation where you have one biological parent, like in one of my cases, one biological parent who had a very severe alcohol dependency, and her substance abuse problem led to great instability in the child's life every time she had interactions with the child or with the caretaker who was the biological father. Now, in this case, we had a reunification of the child. The child was removed from the biological mother, but reunified with the biological father who lived separately. And the judge wanted to close the case because that custody action had been resolved in the father's favor. The father had sole custody. But, and then once the father achieved sole custody of the child, then the court felt comfortable dropping the neglect case because the court needed there to be a written order of sole custody for the father in order to be comfortable that the reunification was a safe result for the child. So a legal custody, in a legal custody situation, there's no termination of parental rights like there is in an adoption. The biological mother in that example I just gave retains her rights as a biological mother. She can seek reasonable visitation, but any judge is going to find that if the biological father cuts off or prevents visitation from happening when he sees her being intoxicated or under the influence, a judge is going to find that to be reasonable. Now, legal custody can be modified similarly to a guardianship result. You can modify custody if there's a substantial and material change in the child's life, and it's in the best interest of the legal custody determination to be modified. Another permanent, so far we've covered reunification, adoption, guardianship, and legal custody. And now the last potential permanency goal for a child who's in the neglect system is called APLA. And that's another planned permanent living arrangement. Now, APLA is essentially long-term foster care, normally done until the child ages out of the system on the 21st birthday. APLA can be with a kinship caregiver, it could be with a non-kin foster parent, or it could be an independent living situation. Normally, these are situations where the child is normally older, a teenager who's being cared for either by kin or non-kin, or is on their own, and the judge does not feel comfortable closing the neglect case because that's a best interest question. Is like, let's say you have a teenager who's got an APLA goal, who, in other words, has not found anyone to adopt them or get guardianship over them or have legal custody over them. Reunification with a biological parent is not an option, not a realistic option for the child. For the young adult, this person might be 20. For the young adult, and the judge has determined that the child's current living arrangement, whether in foster care or in an independent living program where the child is in an apartment on their own with a case manager, going to school or working, the judge just might decide that keeping the case open, having regular hearings, having a social worker going visit the child every couple of weeks, having a guardian ad litem, representing the child's best interests in those hearings, that's the best way to support this child or young adult as that person kind of moves into adulthood. The APLA goal, unlike adoption, reunification, guardianship, and custody, APLA is looked at as the least favorable of the permanency options. And the reason is because it's generally understood that you want a permanency goal that has a child or young adult connected to a family and as strong as possible a bond, so that when that child or young adult becomes an adult, there are strong connections going on into that person's life. When you have either an adoption or a guardianship, it's less likely that you'll run into homelessness and poverty issues for that young adult going forward in life. There's always the possibility of that, but the APLA goal is looked at as one of a permanency goal of last resort. But as I explained, let me just give you an example. You have there are circumstances where the APLA goal is absolutely the best alternative for the client, for the young adult. Let's say you have a 17-year-old client who has biological parents who are really struggling with substance abuse and have been for years. And returning home is just not a good option for the child. And we've recruited and tried a pre-adoptive home. It didn't work. The client wants to be their own person. The 17-year-old doesn't want to be told what to do. They're in school. They're in the 11th grade in high school. They're going every day and getting A's and B's. And they don't have a guardian who's available to care for them. Maybe they've tried and failed, or maybe it just isn't going to work out. And this person is kind of ready to become a young independent adult. In an independent living program where they teach this young adult budgeting, how to cook, how to clean, how to take care of themselves, how to have a bank account, how to get a credit check, all of these things, that just might be the very best situation for a 17-year-old. That might actually be the best way to preserve their relationship with family members, not actually living under the same roof. There are a lot of reasons in different cases why APLA really is the best goal for a client, for a child. Now, the APLA goal also might be an appropriate goal for a child who has very significant medical or mental health needs that one caretaker does not feel capable of handling on their own for the next many, many years. This happens a lot, actually, in the neglect system, where let's say you have a child who is 11 years old, removed from a biological parent's home. This is similar to one of my cases. Removed from a biological parent's home because of the parent's medical issue, but the 11-year-old is significantly mentally retarded and has a very hard time with behavior issues and following directions, and requires very close supervision on a 24/7 basis and a lot of services, therapy, special education services, medical services. There are a lot of medical issues with this child. And the caretaker is a long-term foster parent who loves this child dearly, has committed herself significantly to this child's well-being and wants to going forward, but needs the assistance of a team that is involved in the child's life going forward and feels unable to really provide for this child without the help of the social worker who's coming and coordinating care, working as a case manager, and also coming to see the child on a regular basis. The guardian ad litem is another support for that caretaker for this very kind of challenging child, in order to make sure that the child's interests are represented. The caretaker may feel very much more comforted knowing that there's a lawyer out there who's fighting for the best interests of the child in court, at the school, in meetings, also kind of coordinating the care, and then having regular hearings. There may be a situation where the APLA goal in a situation for a younger child or for an early teen child does make sense, because the court having hearings on a regular basis means that service providers are being held to account, and the judge is making orders, making sure that the government is doing what they need to do. Now, there's always this, there are competing interests about, in a situation like that, whether or not to recruit for adoption for this very difficult and challenging child, or kind of settle in the way a lot of people look at it, settle for an APLA goal. And that kind of walking that tightrope can be a little bit challenging sometimes, because everyone who works with a child might know that they are the sweetest, most wonderful, loving, warm child who is just a pleasure to interact with, which is the child I'm describing. But they might also know that going through the recruitment process, looking for someone to become an adoptive parent to that child with those needs is going to be extremely challenging. And also, when you have a very stable foster home for that child, where the child is thriving, doing very well, meeting as many goals as that child can meet, meeting that child's full potential, no one wants to pull that child out of that foster home unless they absolutely have to, unless they're moving the child to something that is really very, very likely to result in something like an adoption or a guardianship. So that's another consideration for your clients in terms of what do they feel comfortable doing on their own, and what do they feel comfortable doing kind of with the team. And one other thing I should say about that is that when I'm working with clients who have caretakers who are concerned about losing the team and losing the support of the social worker, the GAL, and the judge, one thing that I think is very important to do is to work with caretakers council, with yourselves, to try to find a way to get to guardianship or adoption in a way that replaces that team with another effective, helpful team. So in other words, is there a way for a caretaker to put together a plan with a GAL and the social worker about, let's see, if we did a guardianship or if we did an adoption, what would the mental health services be? What would the medical services be? What would the health insurance coverage be? Would it be HSCSN, healthcare for children with special needs, or would it be Medicaid, or would it be Maryland Medicaid? And if it is Maryland Medicaid, what does that cover? And who could we get? Who could we line up to handle those services? And if there are financial issues that the caretaker has in terms of how expensive it's going to be on a week-to-week, month-to-month basis to care for this child, is there a subsidy that can be negotiated by yourselves with your clients that will allow the client to actually feel comfortable going for guardianship or adoption? You might be able to negotiate that and bring your client to a point where they feel comfortable making that commitment, or you might not. But it's absolutely an issue to consider. So now I've talked about reunification, adoption, guardianship, custody, and APLA. Those are the main permanency goals that children in the system have. And there's a tab in your binder that I believe is at tab C, that's a permanency comparison chart. And if you look at it, it has really all the different legal ramifications of those different permanency goals. It's a really valuable resource that I use all the time when I'm poking around thinking about which permanency goal I'm looking for my client. So now what I'm going to do is kind of give you an overview of the neglect system. And here's some terminology issues. When I say a child is in the neglect system, that means that the child has an open and active neglect case. Now, the neglect case is opened essentially at the initial hearing, is the first hearing of a neglect case, and when the case is opened, there's a jacket in the neglect systems database in DC court, and it's going to be open and active until the judge closes the neglect case. Now, neglect includes abuse, which is physical and sexual abuse, and neglect, which is like improper care, incapacity to care, and things like that. Now, the site is here on your slide, and the statute has a definition of what does it mean to be a neglected child. And at 23019, there are a lot of different ways that the statute defines a neglected child. And just to clarify, the statute doesn't define anything about the parent's behavior being neglectful. The question is whether or not the child, it can be defined as a neglected child. Now, the child can be defined as neglected if he or she is abandoned, if there's physical or sexual or emotional abuse, if the child is without proper parental care and control, if the child is with an incapacitated parent because of the parents being sent to prison or being hospitalized or having some mental incapacity, if the child is with a parent who's high on substances and is incapacitated as a result of substances, it would fall under that subsection. If the parent has handed the child to another caregiver and that other caregiver calls CFSA and says, hey, I was supposed to babysit for 3 hours and the parent's not back and it's been 3 days. That's an unwilling caregiver situation where you have an unwilling caregiver of the child and the caregiver has made a statement that the caregiver is unable to continue to care for the child. There are other circumstances like imminent danger. If, let's say there are siblings in a home and one of the siblings is very badly physically abused by a biological parent and the other sibling wasn't, but was in the same room or was in the same house or came back later that night, if there's an allegation that that other sibling is in imminent danger of abuse, that could be a result. That could be essentially grounds for considering that sibling to be neglected under the statute. And then there's several other provisions about exposure to drugs. That's another way that children can be defined as neglected, is if they're exposed to drugs. Now, these are civil cases, so if the child is determined to be neglected, that means that the court has the authority to determine who has custody and under what conditions that custody is given. The court, if the child is determined to be neglected, can also order parties to participate in different services like drug treatment, parenting classes, anger management, things like that. So now I'm going to give you an overview of the abuse and neglect case just kind of from beginning to end. And I'm just going to run down this slide in terms of how a neglect case proceeds chronologically. First, usually it starts with a hotline call. Someone calls CFSA's hotline to allege that a child somewhere is being abused or neglected. Sometimes it's a teacher, sometimes it's a social worker, sometimes it's a neighbor will make that call. There are a number of people in the community who are considered mandatory reporters of child abuse. That's teachers, people who work with children, counselors. And if they see what they believe to be neglect or abuse, they're required by law to make that phone call to CFSA. Once a phone call comes into CFSA and they're alerted about a potential situation, they'll do an investigation. And during that investigation, CFSA, CPS workers, Child Protective Service caseworkers, these are social workers who are trained in investigation of child abuse, will make a decision about whether or not this child should be removed or not removed. If they decide that the situation is urgent and that the child's safety or well-being is at risk, they'll remove the child from the biological parent's home or from the caretaker's home if it's like the unwilling caretaker case. If they decide that it's significant and substantiated but not urgent, and the child's well-being and health is not imminently at risk, they may leave the child in that placement but open up an in-home case and provide ongoing kind of monitoring and services for the child as that child stays in the home. So that there might be social worker visits, there might be services set up like drug treatment or anger management or something like that, but they might leave the child there and go visit every now and then and stay in touch with the teachers or daycare providers or neighbors to make sure that everything is okay. Now, if the child is removed, CFSA will file a complaint with the court that alleges why it was necessary for the child to be removed. At that time, usually within 24 hours of removal, the court will appoint a guardian ad litem, either from the Children's Law Center or someone from the private GAL panel to represent the child's best interest. That's about it's supposed to happen 24 hours after the removal of the child, within those 24 hours. Now, the next thing that may happen before the initial hearing is a family team meeting. Now, family team meeting is supposed to occur within 72 hours of that initial removal, And the family team meeting is where a coordinator from Child and Family Services learns about the case and tries to find out what are the placement options for this child. Like, let's say there's an aunt, a grandparent, maybe a non-offending spouse who lives in Maryland or who lives somewhere else in DC who can take the child in. What the family team meeting coordinator does is makes calls immediately out to as many relatives, friends, mentors, people who they can find that have a stake in this child's life, and tries to organize a meeting to get them down to Child and Family Services Agency or one of the collaboratives as fast as possible so that they can put together a quick meeting. They can talk about essentially what led to the child's removal, what can we do to ameliorate the problems, the risks for this child, and what can we do to have a plan A, plan B, plan C for where the child is going to stay if a neglect case remains open, which normally they will often remain open from the time of removal, sometimes for days, sometimes for weeks, sometimes for months or years. So they will get everyone together. Grandma will raise her hand in DC and say, I can do it, or an aunt in Maryland say, I can do it, and they'll start working on the paperwork to get licensed as a foster parent. Now, the parents' attorneys are not appointed at the time, normally, that first family team meeting happens. Usually, that FTM is what they're called, happens prior to the parent's appointment. So you may have a situation where the biological parents are sitting there and the guardian ad litem, the lawyer for the child, is sitting there. And there are conversations going on. That's just one point in the process where the GAL has an advantage because the GAL may learn things from the biological parents without their attorneys yet being appointed. The government then files a petition with the court unless they decide to do a 5-day hold. A 5-day hold is a situation where the government feels like it needs further investigation before filing a petition. It may be that the government, in one of my cases, they had learned about a non-offending spouse in DC who's easily able to take the child. They might want a few days to try to organize that, to have the child go straight to the other biological parent and not even petition the case. That's one example. Now, at the initial hearing, that's supposed to be within 72 hours of the removal. Usually the morning of the initial hearing, the court will appoint the lawyers for the biological parents. They'll show up half an hour early to try to talk to their client before the initial hearing. You'll have the initial hearing and potentially a further initial hearing if there was that 5-day hold. That second hearing is called a further initial. And I'll talk later about what happens at the initial hearing. Then after the initial hearing, you'll be having status hearings every now and then, normally. You'll have a mediation that'll be held usually within 30 days of the removal or so. At mediation, there may be a stipulation of the question at mediation usually is that the government is seeking the biological parent or parents to sign a document saying, here's what happened. I'm the biological parent of this child. I got out of hand for a few minutes and I hurt the child when I used a belt. I'm willing to work with the agency on the issues that led to that incident. I very much love my child, and all of these facts lead to the case that this court does have authority over the child, and that the child does meet the definition of being a neglected or abused child. Now, if at mediation there is a stipulation between the government and the biological parent that's signed, then usually what happens is everyone runs from the mediation over to court. They try to get the judge to have a quick hearing. The judge will look at the stipulation, will do a voir dire of the biological parent to make sure that they know what they're signing and that they can either read or that they can discuss it with their lawyer. And if the judge accepts that stipulation, then the question is going to disposition. So that's if, yes, there is a stipulation. On the other side of the chart, if no, then you're going to have a trial. And that's the typical discovery, pretrial hearing. You're going to have a neglect trial. That might be a 2-hour trial. It might be a 3-day trial. After the trial, the judge will make the determination, usually from the bench, of whether or not there's neglect, an adjudication of neglect. If the judge finds that there is neglect, in other words, that the child meets the definition of being a neglected child under those statutory provisions, then you go to disposition, as if you had reached a stipulation. If the judge has the neglect trial, but decides no, that the government has not proven, it's by a preponderance, that there was, that the child met the definition of being a neglected child, then the court is going to close the case. The neglect matter is closed. So, going back to disposition, if you have a disposition either from a stipulation or a trial, the next step is that you have review hearings and permanency hearings over the next several months. Now, the case can be closed where the court terminates jurisdiction for under a number of different circumstances. First, the judge might close the case because of reunification with a biological parent. And I discussed earlier of the reunification goal. If a child does go back to the biological parent, usually it's under something called protective supervision, where initially when the child goes back, the neglect case remains open for a little while, usually for a few months, where there are conditions that the parent has to meet. Maybe services have to be done. The parent has to keep the house open to the social worker and the GAL. The parent has to make sure the child gets to school every day, to therapy once a week. There'll be a number of conditions. And then if, at a later hearing, if the judge says, okay, the reunification looks like it's going well, we're going to close the case now. That determination is close the case if it's in the best interest of the child. So the judge feels like child's back with a biological parent, the case should be closed because the child is safe and the circumstances that led to the neglect or abuse in the first instance have been ameliorated. Another way that the case can get closed is if there's a long-term custodial arrangement, and that includes adoption, guardianship, and custody, the other options that we talked about earlier. And again, the judge is going to want to see that the adoptive parents or the guardians have a good hold on things before the judge closes the case. So that's why under the adoption and guardianship statutes, there's a requirement that you can't have a final adoption decree or a permanent guardianship order until the child has been living with that caretaker for 6 months. So it's built into the statute that the judge is going to have a good look before they close the case at how that arrangement is going out. And another way that the judge can close the case is if the child turns 21. And the moment that the child turns 21, the child has aged out of the system. The judge only has jurisdiction of the child until the child's 21st birthday. Next, on the next slide is the neglect, adjudication, and disposition. So a petition is filed in D.C. Family Court by the Office of the AG alleging that the child is neglected. In the petition, the government is going to list out which counts or factors in that definition in 23019 are met. So if you look at 23019, you'll see these little subsections, 1, 2, 3, 4, 5. The AAG might decide that they are petitioning the case under subsection 2 because there is no proper parental care or control, and number 3 because the parent is incapacitated because they had to go to the hospital. So then in the petition, the government will lay out not only what the counts are, but also lay out the alleged facts that they believe supports their argument that the child meets a definition under those counts. The neglect adjudication, as I mentioned earlier, there's a trial or there's a stipulation, and the burden of proof, again, is a preponderance of evidence. Now, the dispositional hearing, the court makes a custody determination. So let's say there's either a stipulation or there's a trial where the child is adjudicated neglected. The court will either use protective supervision, which is what I mentioned that leads to a potential reunification, where there's custody of the parent with oversight and conditions. There might be a private or third-party placement, and that means that the court at disposition has the authority to place this child with another person, a relative potentially, or a non-relative, where it's in the child's best interest to be placed with that third party. And by the way, that can be with or without CFSA's blessing. Like there might be a parent, there might be an aunt out there that CFSA has refused to go look at their home, has refused to answer their calls, doesn't think that that aunt is a good idea for the kids, but the GAL might be fighting to have that child placed with that aunt. The court does have authority to place a child with a third-party placement under the statute, even without the Child and Family Services Agency blessing that placement. Another possible outcome at disposition is commitment, where the court is committing the child to the legal custody of CFSA and placement of the child in a licensed foster home or some other residence, like either an RTC or, a residential treatment center or some other program. Now, that's the commitment of legal custody to Child and Family Services Agency. Now, on the next slide, we have review and permanency hearings. The initial disposition orders last for no more than 1 or 2 years. Review hearings happen, they're mandatory either 1 or 2 per year, and it's 2 per year if the child is placed out of home, and they're usually held more frequently. So usually every 3 or 4 months or so, sometimes 5 months if things are pretty stable. Permanency hearings are within 12 months after the child's entry into foster care and 6 months thereafter, every 6 months thereafter. Now the permanency goal is set at the first permanency hearing, and in other words, on paper, the court will look at all those permanency goals that we discussed earlier and will put down the permanency goal and put down the achievement date for that permanency goal. The agency, after that determination is made and it's put down on paper at that first permanency hearing, the agency is required to make reasonable efforts to achieve that permanency goal. And at each hearing thereafter, the agency is going to make proffers to the court about what have they done to make reasonable efforts toward achieving those permanency goals. And the court will either accept it and adopt those proffers, or there might be a fight about whether the government's actually done what they need to do to reach those permanency goals. So on this next slide, permanency and the Adoption and Safe Families Act, it's also called ASFA. ASFA was originally a federal funding statute, and now it's part of DC law. It imposes a number of different requirements on child welfare agencies in the court, and it has a number of different deadlines. It requires appropriate planning by the agency for children who are in foster care. And the general idea is that you have to keep the government, the court focused on keeping their eye on the ball for these permanency options. It's very important that children in the foster care system always have permanency goals established and that the government be working toward achieving those goals, or else the kids can languish in the system unnecessarily. Being in the system can be a very stressful and destabilizing thing just in itself. So it's very important that there always be forward movement toward permanency goals. And yes, the permanency goals can sometimes fall through, and sometimes you change them midstream because of necessity, but you always have to have goals that you're moving toward. ASFA also has requirements about terminating the parental rights of the biological parents during a neglect matter, and that a TPR, with some exceptions, TPR is a termination of parental rights. A TPR must be filed by the government if a child is in foster care for 15 of 22 months after entry to foster care. So that keeps the pressure on the court and the government to be moving toward one of those permanency options. And if the biological parents are not doing what they need to do to try to get the child back, there's essentially a clock ticking. And the biological parents need to know that and need to be working toward reunification if that's what they want, if that's what they're striving toward. And if it's going to take a biological parent 3 years to overcome a substance abuse problem, the child will not wait in the foster care system for that to happen. That's generally the idea of that requirement. The next slide is the Family Court Act. And the main requirement here is one family, one judge. And the family court has jurisdiction over a number of different types of cases. The family court handles marriage, separation, divorce, annulment cases, child support cases, custody matters, adoption, intra-family offenses like assault, neglect cases, juvenile matters, and commitment of mentally ill patients. And with all of those different areas, the Family Court Act is striving to have one family, one judge, so that one judge who's handling one type of matter gets assigned another case that comes rolling in, so that that one judge who's familiar with the family, familiar with the circumstances, it's understood that that judge will probably make better decisions in other related family matters. It's not a requirement under the statute that it be one family, one judge. The language of the statute says, to the greatest extent practicable, feasible, and lawful. If an individual who is a party to one action has an immediate family or household member who is party to another action, the individual's action shall be assigned to the same judge or magistrate to whom the immediate family member's action or proceeding is assigned. So it's a matter of practicability. Neglect cases generally, the who's who are the parties in a neglect case? First you have the magistrate judge. Usually it's in front of a magistrate. Occasionally you'll be in front of an associate judge, an Article III judge, but magistrate judges typically handle most abuse and neglect cases. Magistrate judges' final orders are reviewable by an associate judge and then appealable up to the Court of Appeals. You have an assistant attorney general, who's the lawyer for the government, social workers from Child and Family Services Agency or maybe a contracting agency that works with the CFSA, a guardian ad litem who's responsible for representing the best interests of the child, birth parents and their attorneys. Possibly you'll have a foster parent involved in the case as a party, a caregiver, and they can be assigned attorneys by the court, and then possibly an education attorney. An education attorney represents essentially either the biological parent or some surrogate who's been appointed by the court to make education decisions for the child. The education attorney does not represent the child, it represents the caretaker, because it's the caretaker's interest in getting fair and appropriate education services for their child. Licensing. There's a set of requirements that an individual has to complete in order to become a foster parent and be eligible to get foster care payments and a subsidy for caring for children who are in the abuse and neglect system. Now, these are found at the sites that are provided here in the DC municipal regulations, and COMAR stands for the Code of Maryland Regulations. Now, these licensing requirements include classes like parenting classes that they have to take, CPR classes, first aid. They have to go through federal and local police clearances. They have to do a child protective clearance check to see if they've had any hits in terms of being substantiated for abuse or neglect in the past. And that has to be done for all members of the household who are 18 or over. The process also includes home assessments where the social worker is going to come out to the home. They might say, go through the home assessment and say, oh, you don't have a fire extinguisher in your kitchen. You need to please go buy a fire extinguisher so that we can pass you, or something like that, or not enough fire alarms, or if there's a big gaping hole between the first floor and the second floor that someone could fall into, they're going to note that. That needs to get changed. The licensing recertification process, most of your clients will already be licensed foster parents by the time that you're appointed to represent them. But it's real important to remember that your clients need to be recertified annually. And that process is difficult, it's annoying, there's a lot of paperwork to fill out. There might be another home assessment that needs to be done. And I've seen a lot of cases where foster parents are dealing with the messiness of just day-to-day life and work and caring for this child, and then all of a sudden a year goes by pretty quickly, and all of a sudden they're being asked to do this all over again with all the paperwork. the criminal background checks and stuff. So it is, it can be burdensome. But if the foster parent doesn't get that done, they can have their license revoked and the child can get removed from the home. So it's a very important annual ritual for your clients. Party status to the neglect case. The caretaker does not automatically have party status in the neglect case. The attorney, yourselves, need to file motions for party status pursuant to the code that's cited there, so that they can have the same rights as other parties in the case to access to the neglect jacket and to the social file. And you don't need to reinvent the wheel at the Children's Law Center. I know that we have sample motions for party status. They're very basic. They're easy to file, and that shouldn't be too burdensome for your perspective. Case closure. The neglect case can close if a child is successfully reunified, as we talked about, the child turns 21, or there's a long-term permanent order, like for adoption or guardianship or custody. But remember that case closure for something like guardianship or custody, yes, the case is closed technically, but remember that think of it more as dormant in those situations, because it could pop back open if the guardianship or the custody is modified by the judge. And remember that case closure, the big question about when a neglect case ever closes, it's a best interest analysis. If the judge decides that case closure is not in the best interest of the child, that for some reason keeping this case open, having the hearings, having a social worker, having a GAL, having attorneys representing caretakers and parents, if the judge decides that that's the best thing for the client, for the child, the judge is going to keep the case open. And also, if the judge sees a lot of instability in the client's life and just doesn't feel comfortable giving up power, authority to make decisions, to monitor, to maybe hold the government's feet to the fire, or the service provider's feet to the fire, the judge is not going to want to close the case. So that's all I have. Good luck. This is really great work that you're doing. Your work helps form a family. It's one thing that's really amazing about this work representing your clients. Your clients are caretakers for really the most vulnerable population in Washington, D.C. These are kids who've been abused, neglected, bounced from home to home to home. And your work, you get to witness and work on the formation of a new family. And it's really a wonderful job that you do. It's really my favorite part of my job is to witness that synthesis of a family. And it's an awesome thing. And I think you should be really proud of the work, and I hope you really enjoy it.